All right, guys, give it one more minute. You can still see my screen okay?
Yes. Yeah.
Yes, Dave. Yep.
Okay. All right, guys. It's going to be hard for me to see both screens and talk, so I'm going to go into the um, seminar. If you could hold off on questions until the end, I'm going to open up for questions once I get through the presentation. And the recording is started. All right. Thank you as well for being here, guys. Thank you. So this course is part of the subrogation, is part of the mastery course series that I've been putting together. Next month, I'll be talking as well about foreclosure. But tonight we talk about the right of subrogation and how substitution claims protect private trust estates, and is something that, as unknowing sureties, most of us who've lived that way our whole lives, uh, may have a way of recovery. Either way, anytime. Well, let me follow along here. Today we explore a concept that quietly governs millions of financial recoveries each year. And it's not just recoveries, but millions and millions in recoveries, not just, so each recovery turns out to be credits. Most people don't know about it. Most never learn it. But those who understand it often see how they're or when they're paying. Okay, they'll see those situations completely different. So what we're going to cover is why people lose money after paying debts. Everybody that I've ever talked to about the system has always had a chip on their shoulder about paying debts, or, debts and the debt system. Anyway, it gets a lot of us into those rabbit holes that I think we find ourselves looking down today. So we're going to cover what subrogation actually is, where your substitution rights appear in real life, why most claims fail, and how structured claim architecture works. There's a problem. Most people, okay, just pay their obligations, okay? Property, insurance claims, financial accounts, business obligations, groceries, all kinds of different things, right? They never recover the money. It has been a question that's been going around for decades, as long as I've been studying this stuff, wondering how to recover funds that you are required, duty bound, obligated to pay. Okay, they never recover it. Okay, the reason is most people don't understand substitution rights. So when somebody pays a debt, right? Let's say you pay a debt, your energy, you went to work, and you're paying a debt in the name of a legal person, right? And that legal person was the one who owed the debt, but you've been paying as surety, okay? what happens to the rights attached to that debt, to that specific debt? That's the question. And that's what we're going to talk about. Okay. Subrogation is the right to step into the position of the creditor after satisfying an obligation, after paying the debt. And those rights transfer. So let's say a lien threatens a piece of property, right? And we'll say somebody pays the lien. Okay. The original creditor is now satisfied. Instead of somebody paying the lien, let's just call it your trust. You pay the lien through your trust. Okay. The original creditor is paid. Now the question becomes, who now holds the rights that the creditor had? Sorry, guys. All right. So why does it matter? So without substitution rights, payments disappear, obligations are satisfied for free, right? You're the surety. You paid the bill. Uh, it wasn't your obligation. It wasn't your duty that you knew of, although you believed you did. Okay. And responsible parties avoid liability. And these are not just simple topics. If you're not familiar with subrogation, um, it's an extensive topic. Okay, we're not going to cover the entire topic of subrogation here tonight. We're going to give you some insight into what it is, a little bit about how it works, and why it matters. Okay, so subrogation prevents unjust enrichment. Okay. When subrogation appears, it appears everywhere. Insurance claims, mortgage lending, especially in fiduciary administration, and where it attaches, and where most people have been, feel like they've been paying for somebody else their whole life, is those surety relationships. Okay, surety relationships. When you are a surety, you are paying for someone else's debt. Subrogation requires three elements, real simple: payment of the debt, a duty, and documentation that it was paid. Okay? Those are the three elements: payment, duty, and documentation. You have to have them all to prove it. Okay? Was there a duty, or did you do it voluntarily? If you did it voluntarily, you have no right. Right? Equity is not going to aid a volunteer, neither will subrogation. Okay? Okay. Most people believe subrogation is just a simple legal argument. Okay. It is not a legal argument. Okay. It's an actual administrative process. There is tons of case law out there on cases that have been subrogated. It's just simple civil cases mostly, but there are some out there as well that are equitable. Started as an equitable doctrine. But most claims fail when payment can't be proven, authority to pay cannot be proven, and you don't have any documentation, or you don't have all of your documentation, your ducks in a row. All right. So when it comes to subrogation, just like anything else in a court, records, 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 records. They want to see the evidence. They want to see the accounting. Okay. If a payment can't be traced, it didn't exist in a court. Okay. If you don't have the evidence, if you don't have the documentation, the receipts, then it doesn't exist. Okay. So it takes clean administration. So trustees, especially since we're talking about trust estates, okay, and I would say having at least foundational knowledge of subrogation would be helpful. Having a foundational knowledge of your trust estate, how to build one, how to administrate, and how to defend, okay, would definitely help if you are looking to subrogate those payments that you've been making your whole life on behalf of another, we'll call it another, okay? But you're always paying as a trustee, you pay obligations to protect trust property, okay? Those payments can create. It doesn't just automatically create substitution rights, it can create, okay, substitution rights. And that again depends on how you organize and do your administration. So a trustee pays taxes, liens, claims on property, or insurance obligations to protect trust property, okay? When you are paying, is it on behalf of another? Is the trust paying on behalf of another's obligation? Okay. And most often, if you are structured the way that we structure it within the Kingdom of Heaven trust management system, if you're in a proper structure, you'll automatically be creating those recoverable rights, because you could show how the payments move, how title moves, all these different things that you are keeping good records of will be right at your fingertips. All right. So subrogation versus assignment. Okay. Anybody who's done who's had a mortgage may have, most likely has dealt with assignments, right? Especially servicing and different things like that. It's a big difference between subrogation and assignment, transferring of rights by agreement, or substitution of rights after payment. Okay. Subrogation is by operation of law. Okay. You made the payment, you notified that it was created, right, for a duty, right, the duty to protect trust property, we'll say. So you're sending notice. There's administrative process involved in this. Okay, you're creating the evidence that they knew that you were paying the debt of another, and then you made that payment. Okay, after you make the payment, those rights transfer automatically. Okay, big rule: you cannot volunteer, right? The non-volunteer rule. Subrogation does not apply to volunteers. So if you're volunteering like you have been most of your life on behalf, to pay the debts of these obligations that your legal person has, right? You paid the taxes, right, on debts that were owed by the legal person. We'll call it the pass-through trust, right? You paid the debts on behalf of that. You have a right of subrogation. You can make the claim, but it's always nice to create that evidence ahead of time. Okay, but subrogation does not apply to volunteers. If you just volunteer to pay, create no record that there was a duty and that you're doing it because you have a duty to do that, right? You're setting the stage. Person who freely pays without obligation usually can't claim substitution rights. Okay, if you don't have an obligation to pay, you cannot claim substitution rights. Taxes, duty to pay, right? Fees, fines, application fee, all kinds of things, right? Those are by duty. There's a lot of money left on the table that most folks don't know they have a right to. Okay. Subrogation requires a real payment, an actual payment, in order to subrogate the rights of the creditor. Okay. Real payment has to be made, not promises, not intentions, actual payment. Proof of payment. So, what is payment tracing? Okay. It's where the funds came from, where they went, and what obligation, right, was satisfied. It's an obligation, a duty to pay. Okay, you're creating evidence of the right of subrogation. Okay. The paying party has to have authority, trustee authority, a contractual authority, or some other legal obligation. Right? Are you legally obliged to pay the taxes on behalf of the legal person? There's a legal obligation. Just to give an example, I don't know who that is, but if you would just mute out until we get through the presentation, I'll open it up to questions then. Okay, so again, the party that is paying must have authority to pay, right? The surety would have authority to pay. Subrogation is not like what you hear out there online all over the place. So, I lost 20 minutes of my time, and I'm going to ask for $20 million for $1 million for every minute of time they stole from me. It doesn't work like that. Subrogation cannot exceed what was paid. So if you made $1,000 payment on $1,000 debt, okay, you can't recover more than what you paid, right? Subrogation is designed to defend from unjust enrichment, okay? So think equitable, clean hands, right? Restoration, priority. Well, in the course, we talk a lot about priority, priority liens, okay? Most of the time, if you've got a mortgage, the bank has a priority lien. They're in the top position, you may have heard, right? And other liens that are lower may have other claims against that same asset, but they're in lower priority, okay? And again, property disputes, it becomes extremely important, okay? Priority. And a foreclosure or anything to do with real property, okay, priority liens have to be established, maintained too. So equity principles, subrogation developed in courts of equity, right? And again, its purpose is to prevent unjust enrichment. That's what it was created for. Restoration for those who have been held as surety. So subrogation, okay, when you take a subrogation claim, it rests on 5 pillars. Qualification, okay. Qualification could also be authority to pay, okay. Who has the authority to pay? The payment itself, the scope, the procedure, and the proof. When they say scope, a lot of times you'll see or have heard about subrogation. A lot of this happens in insurance claims. So 2 drivers get into an accident. and they each have insurance, right? So each of their own insurance companies pays for doctor visits and things like that for themselves and damages, right? And then you find out that it's at fault. The accident, one of the people was at fault. Now, the one who was not at fault would subrogate the claims or, that were paid out, whether that be for the doctor's visits or loss of work and things that they paid out, they can get back. They can subrogate any claims paid because their insured was not at fault, but they paid out anyway so that they wouldn't, have a problem, whatever. But it happens every day in insurance claims. So just makes for an easy example of how those claims work. Okay. So the claim architecture, right? It's not improvised. Okay. When I say having a little bit of background in finance law and things like that, it's very much like, or any type of law, it's building a case file. Okay. The elements, right? Those 5 elements, every element has to be documented. Okay. It's just like your administrative processes. Everything's documented. You show, notice, you show second notice, third notice, estoppel, whatever it is. Okay. In this case, it's a different type of notice that sets up the subrogation claim. It's a little bit different type of uh, style, but it's still an administrative process. Very, very similar. Right? 2 or 3 witnesses, so 2 or 3 notices. All right. So how does claims fail? Okay, the payment occurs. There's no bank record, no ledger entry, no proof of who paid it or where who had the authority to pay it. Right. So the claim goes nowhere. You're not showing the elements. So what do? We have to document the authority that we're paying by, right? What gives us the right to pay, right? To protect the asset or whatever is uh, owed, right? The debtor, protect the debtor, okay? The payment path, who the payment came from, who it went to, and receipt, right? Obligation satisfied. So you have record, okay? Those things show that you covered the elements in a claim, and most likely your claim would be recognized. And again, if you're doing your administrative process correctly, a lot of these claims are handled administratively. It's an everyday thing, especially in the insurance and the financial world. Okay, so how do you use it? Okay, subrogation you can use to protect property, to recover payments that were made, to preserve equity. Okay, and just keep in the back of your mind who you've been a surety for throughout your life. And what time, in your life have you stepped in and paid a debt that wasn't yours to pay for someone else? Or with a surety or a co-signer for somebody else? Again, insurance recoveries, mortgages, fiduciary administration, property protection. These are a lot of times where these claims are arising in courts. Okay. And again, it's a claim. So claim is a right. Claim is a right. Okay. When you're talking about subrogation, okay, when you hear folks talking about subrogation in the freedom community, we'll call it, You will hear a lot of stuff about doctrine. Okay. This is what the rule says. This is what that rule says. Okay. Um, Great for knowledge, not so great for practical application. Okay. And being able to utilize subrogation definitely depends on the administrative process and how you administrate and set that up. Theories, right? There is no, if you've heard, I don't know if you've been in calls before on subrogation. Uh, I've been in on quite a few, and usually it's this code, this case law, this theory, blah, 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 blah. They don't get into procedure. They don't explain how to make claims and what it takes to put a claim together. Okay, you're not getting practical application, mostly theory. So we build a claim architecture where you are most likely to succeed in your subrogation claims. And again, this is not something that it's not a simple topic, okay? But I do try to make it as simple as possible on how to do this. If anybody, I know there's a lot of folks on this call that are taking courses, even though the information is probably more master's level information, I still put it together in a very simple way that even a beginner could understand it. And again, it builds on those foundational courses as well, because what we're doing here is in relation to managing your estate, managing your trust, managing your affairs in private. Okay. Could you utilize the principles, take this course and learn how to utilize subrogation and do it effectively? Sure can. Um, but I am a firm believer that if you're going to do it with your foundation set up and do it behind uh, a shield. If you're doing things directly, you have to overcome so much before you'll ever even be heard. Okay. So let's say you're doing business as right? DBA, right? Which is attached to your social number, right? It's you doing business as. You can even have a trade name and do all that fun stuff. And basically you're going to work for yourself. You've got some customers and you get your money comes in every month, and then you have your expenses. However, you're not going to be able to utilize that in taxes the same way because you're taxed as an individual, not as a business. So they don't take the write-offs the way that you would if it was an LLC or something like that. But most folks operate every day. Your income comes from a job. It's the same thing. You pay your bills, and you're doing all of this in that legal person, right? That's me, and you're joining yourself to it. That's the big overcoming. The big thing you'd have to overcome, where having the proper foundation makes these types of things a whole lot easier to deal with, because there you're just doing your job as the proper fiduciary. Okay, you don't have to overcome, this is I'm a man or I'm a woman or any of that sovereign nonsense. Anyway, the course, it's 100 lessons. We do real case analysis, real administrative claim system that works. Explains how to do payment tracing, do allocation math so that you're properly stating your claim. Okay. Lien priority preservation, enforcement procedure and rights. Okay. We go into depth on this topic in the subrogation course. So it was built for trustees, estate administrators, property stewards, and anybody who's serious about, getting reimbursed, subrogating for paying your entire lives. You've been a surety for a legal person, a DBA. And if you frame the claim properly, you can utilize this. You can utilize this in your everyday administration. So the course will give you clarity about substitution rights, administrative framework, strategic insights into financial claims that I'm sure you're not hearing in most of the seminars that are out there. So why does it matter? Okay, why do you need to understand about substitution rights and subrogation? When you make a payment, and that payment is for the name on the bill, okay, you made a payment. You had a duty to make a payment in order to keep the electric on, right? There was an obligation. And you paid the bill on behalf of that name. Okay? If you understand how subrogation works, you can get financial recovery. All right. So we introduced a bit of the doctrine of subrogation. Okay. Like I said, the course, 100 lessons, very in-depth teaching with templates and the complete, architecture for making subrogation claims. If you understand it and get to a point where you're doing your accounting, you're keeping good records, okay, then understanding when your substitution rights arise, anything leaving your trust estate, okay, or coming into your trust estate, and you are properly accounting, okay, you will see, you'll be able to see right off, like, little gems that are sitting there waiting just for you to, pull back and get those financial, get those financial benefits out that you paid for some other party as surety. Recoverable claims. That's what you're going to see. You will see how payment may be an opportunity for subrogation and recovering monies that were paid by obligation on another's behalf. So again, of course, we provide a structured system for building these enforceable claims, right? If you do want to, and I don't know, since the last seminar, a lot's changed on the website. I'm going to be hopefully be able to pull this Telegram group into the site, so even be able to do this from within the bulletproofsolutions.org website. Automating quite a few things. Things are changing. This new course literally was just went live, I think about 2, maybe 3 weeks ago. So you guys are the first to hear about it, other than those students that are already in courses. But if you do want to explore the curriculum for the master course, you can get on the website, bulletproofsolutions.org. If you've never been there before, if this is your first seminar, if you go there, sign up for the free membership. I will open that up for the month of April, and you'll have full access to the site for the month of April. Just shoot me when you sign up as a free member, send me a text with your email, okay, within the Telegram group, and let me know that you signed up, and I will turn that into a platinum membership. So you have full access to the site, you get access to the library, and you can download books. There are podcasts, at least 50 podcasts in there from How to Win in Court Without a Liar. And there's a lot of new things coming as well. There'll be a archive of recordings for our Sunday calls, and our students will have access to all of the Thursday calls. We do a student call on Thursday evenings on Telegram, and all those things will be added, and quite a few new things going to be coming up on the website, as well as, like I said, you'll be able to get in, look at all the different courses and the full curriculums, which will give you a real good overview of what you're getting here in this subrogation master course. Okay. And it's just like everything else. I mean, you go into court, okay, you can argue all you want. That's what they love. We don't argue, okay. We can prove a claim without arguing, right? Facts speak for themselves, okay. Establishing those facts properly so that you are giving your subrogation claim the highest chance of success. That's the important part. Okay, it's about proving it. Okay. All right. So I'm going to open this up to questions. Hopefully you guys can still hear me, and I'm going to open it up to questions on the topic.
So
Go ahead, Kevin.
can we get the co-sureties to pay? Is that a subrogation claim when you have a co-surety that's on, say, like the birth certificate, the signature that's on that? Is that a subrogation case?
That absolutely could be, right? I mean, they signed on as a surety, right? They created that legal person.
So if you took your monthly bills and did a spreadsheet on them, had all the copies of all your receipts and submitted those, is that something that would be an administrative process?
It would be, I wouldn't say that's the administrative process. You have to set the stage that this is going to happen, right? And so I am trustee on behalf of my pass-through, right? I'm operating from my management trust. I am paying an obligation that pass-through owes in order to protect the electric from going off, okay? Or them starving to death, right? And yes, you keep your receipts, but again, you have to set up through administrative process between you and that co-surety that hasn't been paying their part.
So that would be through your straw man trust then?
Correct. It'd be through your, through their trust structure, from your management trust would have the right, the interpleader claim, right, would be a right of subrogation on behalf of that, all caps, legal person, entity, to which your trust holds legal title, correct?
Yeah, right. Yep.
You gotta create the board, right? If you're going to play the game, you got to create the board. So all the parts have to be, all the pieces have to be in their proper spot.
Right, but you're not sending all that information in. What you're doing is you're making the claim, and you have the structure behind you to make it I'll say legal, but I don't mean legal. I mean proper, behind the scenes.
Proper.
So that if you had to protect or defend it, you could do that.
Yes, absolutely. Absolutely. That's the whole point. You're creating your accounting and your administrative process, the evidence of your administrative process. And that's setting the stage for an immediate claim or, eminent claim that's going to be made.
So is it the typical 2 to 3 notice, clean hands doctrine?
Yes, so obviously coming from trust, we want to stay in that equitable realm, and subrogation is an equitable doctrine. There is, again, statutory equity, which again would be commercial or contractual, right? By right, you have a right of subrogation by contract. It wasn't an assignment, right? But a legitimate surety agreement, like an insurance contract or a bond company writes a bond, right? They become the surety for the bonded party.
So could you be considered an assignee de sans tort because we've always been assumed to be the surety for that birth certificate?
Well, if you think about how far there's no statute of limitations on fraud, if that's what you're saying.
Sure, that's what I'm asking, but as fraud goes, I'm just trying to put the players who the pieces are.
Yeah, I mean, you can go all the way back. So as long as you've been the surety or acting as a surety for that thing, you have a right of subrogation. It hasn't been expressed because you didn't know you had that right. Right? But so latches wouldn't come into play. You didn't sleep on the right. You didn't even know you had the right. Right? It was never disclosed. But the law assumes that you know the law. And again, that'll be argued. So how do you defend against it?
Well, we just show the receipt for paying for your course. That's what we found out.
No, how do you, again, if you didn't know that you had the right all these years to subrogate those things that you were obligated to pay because somebody said so, right? And just because they said so, you've been paying them. Right?
You would essentially, if you're going to use the birth certificate, you're taking either the state or the province, to court. Essentially, if you're taking it that far, you're giving them notice, and then if they don't, what would they even do? If you give them notice, then how would that work?
I think an accounting is due, but isn't an accounting due anyway if you're doing your administrative process correctly?
Okay, well, I guess that's the other question. Can you do this prior to that, or is it kind of rolled into all of that?
Well, I mean, I would say that, if you don't know what's been paid in where there's a record, that's why it's important to have a record, right? You have receipts from 20 years ago, 10 years ago, 5 years ago that show that you had a right because you made this payment and you were the surety and not the debtor.
I got about 3 and a half years of receipts.
Okay. And again, so if you're looking at accounting, if you're looking at a full accounting and you're doing your administrative process, like you would going through your second course and getting, and putting together and administrating those interfaces, you're looking for an accounting. Subrogation would be a whole heck of a lot easier to prove if you had that accounting, right? Because you wouldn't know the full extent of your claim. But for anything that you can prove, you say you have 3.5 years worth, there's a great place to start because you have the evidence. And it wouldn't hurt to start, today, knowing that if you're making payments for that thing, and again, now, if you're in the proper trust structure, your management trust, the fiduciary, right, is making payments for all these other trusts, which would automatically give those, it's a subrogation situation there. So setting that up in-house and showing the web of how it's done is great for financial accounting once it's on the private side, especially. But being able to get that accounting would be huge, right? If you can get the full accounting, then you can actually go in and pick out everything that was laid out by you while playing surety is subrogated. You have a right to subrogate.
What kind of entities can you subrogate against? I'm assuming that if we go to Costco, we can't subrogate them. But like a utility, like a hydro bill, that sort of thing, can you subrogate those, or are you always going back to that surety position of the BC?
Well, if you're doing it yourself, you're always going back to that surety position with the BC. And again, right, isn't that where everything is ordered, right? From the Treasury?
Yeah, that's where the third party would be, because you're actually two of those parties. You're given the legal name, but you're operating behind the scenes as the actual person doing the work, the man or the woman, but the one actually making payments.
Right. So yeah, I mean, again, that's the co-surety on the birth certificate, right? What we talked about earlier, which you asked, that individual or party should have been the responsible party. You never knew you were even acting as a surety, and shouldn't have been ever acting as a surety. You should have always been in the beneficiary position in that trust with no obligation and no duty, because the trustee has the duty and obligation, not the beneficiary. Beneficiary doesn't have to even accept the benefit nonetheless pay for the benefit.
Right. So because it's going into equity, are we going after the actual person that is in that position of that office? In my case, I'm in British Columbia, and the surety for the birth certificates has actually changed. It was one person for until last year, and now it's changed. So are we actually naming the person, or are we going after the office?
It's the office. It doesn't become the person until after your administrative process. If they don't do what they're supposed to do, then you go after the in personam in equity, right? Because before that, you're basically notifying them of you're doing business, basically, right? You're doing your administrative process. You're giving notice, right? So after that, then equity would attach. They've had full notice. They've had opportunity to cure. They've had opportunity to disclose. They've had opportunity to account. There's a lot of different things that you're giving notice about. And if they don't, then if you had to bring a claim against the person. You're not subrogating against that person, okay? Only there's a breach of fiduciary duty, a breach of trust, okay, for them not doing what they're supposed to do, okay? But the right of subrogation, that right is because as surety, have been paying that entity, right, where the co-surety should have been paying. So basically, it's like going back to the car accident, right? You found out that there's fault. And now you are bringing your claim, right, for all the things you've been paying for against the one who was supposed to be paying for them in the first place. Does that make sense?
Yep. Yeah, we in the Criminal Code of Canada, we have Section 336. It's actually a 14-year sentence for any official in a official capacity that is a criminal breach of trust.
So there's a little bit of teeth you might be able to use there. And again, I mean, hopefully you don't have to go that far. Bringing the claim. Really, what do they lose? What do they care? If you walked out and stopped, and they weren't able to tap your, tap your well, they still have millions of others that they just keep going. Again, we're not fixing the world. We're trying to administrate our own estate. And, again, if there are assets, if there are rights, if there are, securities or anything of value, including the administrative records that are being held, then, you have a right as the legal title holder to that asset, to that property, because it's no longer in their subject matter. It's no longer in the purview of their administration. And again, we do that through our our original administration. This right of subrogation has its own style of administration. I'll tell you that. But having a good understanding of the administrative process will make doing this administrative process for subrogation that much easier.
What about a credit card then? Subrogating the creditor in a credit card situation, one of the banks.
Right.
Can you try to get, like, if you don't have all of the records, all of the statements, could you require them to, because they have the statements?
Sure.
And with that, you could then document
Send notice. Yeah. Send notice that you have, as trustee, you've been, or as surety, you've been paying these payments on behalf of another. And again, so you're getting creditor rights when you make the payment. Okay. You become the creditor. Okay. You get the right to go back after that co-surety. That's where your return comes back. That's where the claim goes. Does that make sense?
Who is the co-surety then? Is that's the bank, or
back to no, they're not a surety on it. Actually, in the banking situation, they very well might be. They very well might be, because they're supposed to, being that it's a credit situation, that there was no monies. They were a surety, okay? They were the creditor, right? They were a surety. They lent the money, so they were the creditor, not the surety. You were the surety. Your straw man was is the debtor, right? That you were surety for.
Yes, the legal name is the debtor. Yeah.
Right. But if you made the payment, you get creditor rights. So you're getting the same rights as the credit card company. You're taking that right from them. Okay. And you are you have a right to collect. Now, where are you going to collect? In this case, would be for co-surety. Again, if you're doing your administration, that right of subrogation comes in with that co-surety for the legal person, the one who had the fiscal or fiduciary duty and the legal obligation to take care of those things.
Right, because when you subrogate, you can't get the payments back because they're made to the creditor, and that's all correct. The only thing, if you subrogate the creditor, what you're getting is anything that they're holding, you step into their position of holding that stuff, so you can get any kind of liens or anything, but you can't get the payments back. You'd have to get the payments back from the co-surety.
Correct. So you would get the deed, right, to the mortgage or to the property or to the security interest, right? These are things that you would get back.
And
Yeah.
In the case of a credit card, then are you subrogating and then getting the original note back and the accounting of where that went?
Well, see, that's the thing. You're talking about an accounting. What you're getting is I paid, you bought something on a credit card, right? Whatever you bought on the card that month. And you'd have to show that your receipts, right? They have a record of the transaction. Okay. But you would want them to know, especially if this is obviously it's a recurring payment every month, right? So what you'd want the credit card company to know is that the trust is paying on behalf of the card holder, right? The beneficiary, to make sure that they have available credit, right? And that you are notifying them of your right of subrogation, the trust's right of subrogation.
Well, it doesn't
So
have to be a default. You can set this up administratively so that you can collect every month. Is that what I'm hearing you say?
Not? Why not? You could send in that bill to the co-surety every month. Why not? It's an expense, right? It's being expensed monthly. You could do it quarterly. You could do it, it all depends on your own accounting of how you do your accounting by, your trust does your account, but you can make your claim monthly. You can make, it creates more paperwork. You can do it quarterly, bi-monthly, however you choose in your administration. But again, it's an old, if it's a recurring payment, it's going to happen again and again and again and again. So you set it up so that the trust is making the payment for the beneficiary, the card holder, right? That's your administration. Your administrative process is making them aware, right? You're not saying they're going to have to pay. They don't care because they're getting paid, right? You're setting up your claim to go after the co-surety, the one who was supposed to pay, the fiduciary.
Right. So once that's set up, you just live off your credit card.
That is a very well a possibility if you get the treasurer to make those payments. Isn't it the treasury in a fiat system that owes the debt? I mean, I'm pretty sure that's what I've read in the U.S. All debts are debts of the United States of America.
Well, I think they're for most of the world. Like for Canada, I know that it goes back to the U.S. because it's they are the debtor of last resort. They are the ones that are publicly have stated they are responsible for all debts, and because there is nothing tied to any kind of backing anymore,
Asset, right?
To any assets, right? Everyone's gone floating, and it's all based on essentially the five international trade dollars.
Well,
the
and if
euro.
you look at what's going on right now with, the European Union and all these other countries that are, since Bretton Woods has crashed, no longer petrodollar and the go-to currency for the world, um, it's becoming a lot harder um, for them to do anything. They don't have that borrowing power like they had, not even close. Probably big reason why things are going on right now in Iran. Last holdout for a central bank. So
Means that's
lots
not
of
where the
interest,
problem
lots
is.
of right. No, no, no. But again, I mean, if you look at how the central bank has been utilized over the years, 1933, and this beautiful fiat system we all find ourselves in. If it's a debt system and everything is, based on debt, it has to be a slave system because a borrower is always slave to the lender. And this is where owning nothing and having nothing in your name frees you, which is kind of why this whole system exists to begin with that we're talking about here. That's why I created this whole, system of managing your affairs so that you can separate yourself um, as best as you can administrate. Okay, because again, when we go to court, if you go into a courtroom and you don't understand what they're doing, or even if you need to be there, or how to deal with it when you get there, um, a lot of people aren't going to go and pay thousands of dollars to hire a lawyer and, you know, get aggravated because they think they have to. And most of them probably would have done better knowing nothing and going in than hiring an attorney because, again, they're paid to argue. And as long as you'll want them to argue for you, they're going to get paid. It has nothing to do with your case. Nobody is going to protect your interests like you. Nobody cares about them like you. So it's very important, to know things like this or how to manage your affairs, how to separate those things so that you can manage it, create evidence. And, when I was a kid, they used to say, well, you have to register your property so that in case something gets stolen, we know that it belongs to you and we can get it back to you, right? Register your car, register your house, your kids, your everything, right? And they didn't tell you that you were going to be surety for this thing they call a legal person, right? A lot of folks don't understand that. But you're a surety for uh, a DBA business, right? If you look at the public as commerce, and you have to, okay, um, then everything is business. So if you are without LLC or limited liability, right? If you're not a corporate entity, a separate entity, the corporate sole or the sole proprietorship or doing business as all comes back to that legal person. It's operated as a business in commerce. And if you're doing, even if I'm doing business as ABC Lawn Mowing, and but it's your social that's attached to ABC Lawn Mowing, you're getting taxed just like it was if you were your all caps name there, the legal person. There's no difference, not even a little bit. So again, you're surety for that DBA for everything you do in commerce in that name. You have been possibly unknowingly uh, a surety for it. This is why subrogation is such a big topic, because you've had a right to subrogate everything that you've ever done in that name because you're paying a debt that doesn't belong to you. Doesn't mean
Big
it didn't
picture is
belong to them, and you did. Well, I don't want to. Well, give me 1 second, Kelly. I don't want to say that you didn't cause it. People do go and they buy things and they use that name and they animate it. Okay. So take responsibility where responsibility lies. But if you understand subrogation, you can get uh, the proper party to pay the debt. And put it that way. Go ahead, Kevin. I'm sorry.
No, I was just saying that everything's prepaid. You just have to properly claim it.
Exactly. Exactly. Any other questions?
With the fiduciary, we'll say the bank. Once it's in the private administration, and the private administration is doing the subrogation, putting the subrogation claim in, the full accounting is provided by the financial institution. Since equity acts in personam, if the corporation does not comply, then the claim would go to the CEO or president, the man or woman themselves.
No.
No?
The bank is the creditor. Okay. They're the creditor. Okay. In order for subrogation to work, a party who has an interest, okay, not the party who is the debtor, okay. So let's say have a car and you miss some payments and you're in danger of being your car being picked up and taken back, right? So the trust reaches in and pays the back payments, takes it out of debt, provided payment where it wasn't their obligation. Okay. There was a duty that the beneficiary had. And in order to protect the trust asset, the trust had to make the payment, right? It was a obligation that way, okay, but not the obligated party, not the debtor. A third party pays the debt for the second party and gains the creditor's rights against the debtor, okay? I paid it, now I have the creditor's rights. Now I may have uh, maybe I paid off the car and or the trust paid off the car, and now the trust is the creditor, owns the car outright. All debt would be owed to the trust. So let's say it's your grandchild and got a loan from the car as a part of the trust beneficiary. They couldn't make their payment. The vehicle is still part of the trust, but they couldn't make the payment. So the trust makes the payment, pays off the vehicle. That grandchild would have a loan that's due to the trust. Okay. And the trust would hold the lien on the property. So that's how it gets creditor rights. But if you were talking about getting subrogating rights, kind of like what Kevin and I were talking about, you go back to the surety, the co-surety. You go back to the co-surety. Okay. That is, the United States is, responsible for all debts. The co-surety on the BC, like Kevin was saying.
Yeah. Okay, where I'm coming from here is the account is in good standing. The debtor has been making the payments, and you're doing a proactive administrative process on the account to, questioning the bank's capacity and standing and authority and their creditor status, their creditor standing. So through that administrative process, they're now in, their responses are such that if they answer with the way the notices are structured, if they answer, they shoot themselves in the foot. If they don't answer, they shoot themselves in the foot. So
But
that
that's
opens.
not that's not subrogation.
No, but that the subrogation. I'm getting to the subrogation because in the notice it's worked. The subrogation part is worked into the notice. It's giving notice of the possibility of subrogation once the full accounting has been acquired. So at the end, now I have the administrative record is established and they're in estoppel. You put the claim into the court to, because they haven't provided the accounting. So now the court orders the accounting from the
Yeah,
original creditor.
you're that is you're going into administration, but again, that type of administration is not the same as the subrogation. Um, and what you're talking about would be something you would do once you set up your trust estate and now you're starting to administrate. Those are those types of things that you would do at that point. Okay. This, if you're dealing with a bank on a loan, whether it be for a mortgage or for a vehicle or whatever it is, okay. Um, Again, there's a lot more to understanding that interface, okay, between your estate and the bank and what you're trying to do. I mean, if you're trying to do equitable foreclosure, that you believe that the bank did not provide anything in the transaction, and you're trying to get discovery and accounting and things like that. It's a different accounting, it's a different type of administrative process than what we're talking about here tonight. But, that's something we could definitely talk about on our Thursday call.
But the debtor in that case has not been servicing the loan because the debtor is the birth certificate name, which is actually the king or the Canada or British Columbia or whoever there is the crown essentially is the debtor that has not been making the payments, but we have as the sureties, and so then we have to go after the co-surety, which would be your Register General or whatever.
Yeah, the deputy registrar general, whoever executed the
Yes.
certificate of live birth.
Right, the co-surety. That's
Right.
what I was saying is co-surety. So yes, and in that respect, yes, but the bank don't get your administrative processes mixed up, because you're doing different things for different reasons. And when you're dealing with the right of subrogation, it's a totally different style. I'll say style because an administrative process is a process of notices. Okay. But these notices are very specific in setting up your claim architecture. That's why I'm trying to explain that don't get your administrative processes mixed up. But I'm tying it back. Thank you, Kevin, for tying it back into subrogation and how that would play out. So it's just part of you don't want to treat the bank, the creditor, okay, like the co-surety, because that's not the case.
Correct. Okay. Thank you.
Yeah. Somebody else have a question?
I've just been listening in, and it sounds like we thought that, well, we've talked about this on these calls before, but it sounds like out the gate, we were using our own name. I guess that was from the old days in the 60s. Nobody knew about this. So we've been paying ever since. So myself, I got like 30 years with a banker's boxes full of bills I paid that I honestly thought were mine. And I guess that's why they gave me a good credit rating, as Johnny on the
Well,
spot
again,
to
I
pay.
mean, when you start, when you manage your own affairs and you're dealing with these things and creating your own accounting structure and accounting for all of these things, I mean, if you could put them each in their own file, um, look at them, like you're saying, all these things that you've been doing all these years, it's a different way of dealing with stuff. a different way of keeping records, so with a purpose. Okay. These administrative processes, we do administrate or we don't every day. And the public is, alive and well. All these public trustees, these public servants are out there doing a real bang up job managing everybody's affairs. Most people can't manage their own affairs hard enough, which is why, the system exists now, both public and private. Um, and it's always been, I guess, that you either manage your own affairs or have them managed by your guardian. And that's kind of how it is out there, pretty much anywhere you're at or anywhere you find yourself.
Yeah, I think we're all the people that are on these type of calls are now enrolled in taking a course. Had they known out the gate that a trust was being set up, like it would just been disclosed at the beginning, the public trustees would have been doing all the accounting, and we would have been enjoying, I don't know, the fruits of the trust, the fruits of our benefit or our labors or anything else. There wouldn't be such a, I think sometimes like the national debt is probably what might be, what's actually.
Well, that's an indicator. That's the indicator. So just that there is national debts. Okay, these are debts, and who owes these debts? The citizens, right? The ones they call citizens. Well, that legal person is the citizen. It's not you. That I can prove. And most of you probably know it already. You are not that legal person. You're not that legal citizen, if they want to call it that. Okay. But it was a way for them to administrate, keep records, right? And everybody just lined up to sign up and register their property into this system so they can get some benefits. It was how it was sold. It's how it's always sold.
Yeah, it's just like at the banks advertising they loan money, but in fact, maybe they don't, or in fact, maybe it's the other way around. The other was, I think there's others that were discussing about the disclosure, in regard to birth certificates, not to be used for identification.
I wanted to sorry, Tom, but I want to show for this call, wonderful stuff. We can talk about this stuff on Thursdays, but for this, I want to keep the questions to the topic of subrogation just to keep it tight here. So if you could frame the question in as it pertains to subrogation and those subrogation rights.
Okay, it is a little bit. It's just a matter of, hey, had we known out the gate that we're talking. Kevin was talking about the birth certificate and that the crown or the king or they got their stamps on it, so they're the ones that created that. So they should have been paying all along. Had they just let us know out the gate, it would have been a mess, right? And so here we are, right? We're having to go back our whole life, 60 years worth, But
they're not letting you know that any of this stuff exists behind the scenes. They don't keep, they're keeping the accounting, right? But they don't tell you how this all works together. They just say, here, sign up and register. Where you are registering your rights away for privileges, and that's just how it is. It was you did it voluntarily because you were told that you had to. That's how it works. So
yeah, by them, by threat. That's the case.
By threat, by intimidation, by education or indoctrination. I mean, we've learned our whole lives that we were supposed to do it this way. Right? Our parents learned the same thing. Everybody does it because that's what we've always done. But that doesn't mean that that's the right way to do it. And it doesn't mean that everybody's doing it. Right? There's a lot of people, and we talk about this stuff. We talk about legacy and creating an inheritance for our children and our children's children. and being able to do that without um, without being extorted or lied to or affected by the corruption of those that have been managing it. And the only way to do that is to take it back into your administrative structure and to administrate properly, creating the records. Go ahead. Go ahead.
I couldn't agree with you better. But it's we are a small pile of minnows in a big pond, and hopefully we all succeed. It's going to be a very interesting adventure to do that.
Well, but, again, I mean, you don't have, and again, you can't affect this for anybody other than you. And that's the same thing with it. You don't have rights unless you stand on those rights, right? Again, the only one that needs to change is ourselves. The only one that I need to manage better is me. And that's the only one that I could possibly manage anyway. And it's hard enough to do. So
you're totally
we don't have to think on that big. I'm getting a lot of feedback, guys. If you're not speaking, please mute. Appreciate it. We don't have to look at the big giant system that's coming to oppress us or anything. The only things that are oppressing us was our lack of understanding. Okay, we volunteered for these things. So when we free our mind and go, you know what, I just don't want to participate, so I'm going to operate and manage my own affairs rather than having the public manage them on my behalf. Taking responsibility for managing your own affairs. That's the first part. And it's also the very way that you recognize that you have a right of subrogation in bringing this back to where we started here.
Well,
when you understand. Go ahead, Kim.
We have a game that is being played, but we're, luckily there's people like you, David, that have brought stuff forward that shows us how to play the game properly. And by learning our administrative process, we can stop complaining about what's been done and all the woe is me, and learn how to play it properly and set it up to win.
Yeah, that's fine. But he was talking about in the meeting about the volunteering part of the subrogation. If you've never known about it, you really never volunteered. You just didn't even know about it. And then the other hand is that, on the side of the road or here or there's always so many kinds of threats that you have to be this or you have to be that. It's like, well, out of fear, sometimes you capitulate just to save the day or yourself from being
and that's where subrogation comes in, Tom. That's where subrogation comes in. Cop pulls you over on the side of the road, says you were speeding and you got the license, right? And you go, well, okay, I guess I'm going to just go pay this ticket, right, to save yourself a headache. But if you're doing it properly, you're paying a duty that's not yours. It's the legal person's duty. And you could subrogate that.
Yeah, no, I'm not arguing with you. I'm not arguing with you at all. I know.
I'm just trying to.
I'm just a matter of most of the people don't even know about that. We're just a very a handful of people who got tipped off, thankfully. And you're here and you're showing a different way, which is fabulous. So we appreciate it very much. And but many times maybe a lot of members here have probably had an experience where, if they don't pay, they're going to steal the house, or they do this, they do that. And they wonder, how could they do that? You just paid everything all off, or, what goes on? And it's such a big mystery that you can't touch it. You can't quite, something's wrong, but you just don't know exactly what it is. And I think the majority of people don't have a clue. So they're in for a big wake up call with economic challenging times going on. They're going to wonder, hey, I lost everything, but I built it. I paid for it. I did it myself. How does somebody else have a claim to it? Oh, they must have shirked their duties, or must have been involved in an interface, that I didn't even know I was involved in.
Well,
So
that's
you mentioned,
where, that's why doing your, when you're doing your assignments and when, with the establishing your trust estate course, you're going and inventorying those interfaces and looking at them, analyzing them for how do you deal with it? And again, it's becoming aware of those interactions and how they work and having an idea, an intention, or of either participating or not, and then doing the proper administration. So you're going to learn, Tom,
okay, well,
as you
thank
keep
you very
going.
much. Yeah, you keep going. I just might be the only one in the small town near Prince George that knows this well. Next thing you know, the neighbors
That's all
are
right.
out in the street. Wow. Okay, thank you very much. Good going for your website too. Fabulous.
All right. Any more questions, guys? I'll take a couple more questions and we're going to wrap it up.
I have one. Can you hear me?
Sure. Yes. Go ahead, Tom.
Okay, we're not allowed to be with unjust enrichment, but yet are they not being unjust enrichment by not teaching us what we need to know or what we should have known?
Are they? Yeah, of course, there's been a lot of unjust enrichment when it comes to the public trust, for sure. That not telling you that you're surety for this vehicle that you're driving through commerce every day. Of course, there's a lot of different things that can be claimed, but that is, not where subrogation comes in. Subrogation, I mean, it is for sure, because again, you're finding out that you've been volunteering for paying a debt that you had a right to subrogate this whole time, unknowingly, right? But yeah, I mean, there's a lot of other claims that can be made that they intentionally did not disclose all the negative benefits of participating in their Ponzi scheme / public trust commerce system, right? And there's 100 things you could probably come up with to say that we were duped or whatever. Subrogation is just a simple tool where if you've been acting as the surety this whole time, that somehow there's a right in there. There is a right. It's a right of subrogation to recoup what has been paid, actually paid by you on behalf of that thing that they created on your behalf. So, yeah, I mean, there's a lot of things that you could say about the system and how horrible it is and how wrong it is, but it's up to us to mitigate our own interaction with it, however we interface with it, and mitigate it down to as minuscule as possible, if at all. If you don't need their benefits, then why bother at all? So again,
I've been trying to
Under trust law, though, they do not have to tell you. The beneficiary does not have to be notified that a trust exists. But when you find out, you can, first of all, everything's being held in trust. It's not necessarily a trust. It's not a trust in your name. And what they claim is that the beneficiary is actually missing. And that's part of your administration process when you let them know, hey, I'm alive. Here I am. I'm making a claim. I'm putting it into this trust, and it's being administered now. Now they can't ignore it. So that's where the big shell game is. But they're doing it all legally. They're administrating and keeping records of it all. But they don't have to tell you.
But in that respect, sorry, Kevin, but in that respect, it's noticeable that you and me as people or men that got a home or a farm or whatever else, the value keeps increasing by all the improvements being. So obviously we are alive. Like, where does all this value come from? These numbers represent energy, and people are alive, represented by those numbers. And also what I guess a commercial market might bear if you're trading titles or certificates back and forth. So I don't see how they could just, put their head in the sand, because they too are just men and women, and they
It's
have to
debt
go.
accounting. It's debt accounting. They're accounting for a bankruptcy. It's debt accounting. And
Oh,
again,
you're saying
yeah,
they have a big debt, and they're accounting for a debt by the value that we produce.
no, the debt they created. Okay, yeah, we're going to go right back to Schoolhouse Rock. I don't know if you remember that, but a bill gets introduced right here in the U.S. A bill gets introduced to the legislature. A bill. It's contemplated. Okay, this is a commercial transaction. That bill creates whatever act of Congress, right, and becomes a law. The bill is now due by the debtor, the legal person known as citizen. And then a debt is created. And again, all of this stuff is fiction land. It's flatland, it's paper, it's 2D. This is not where you and I live. And it is a paper game. It's a paper chase. And it's about who has the proper evidence. So, and again, it's organizing. And then taking away, if I don't trust you, I don't want to be around you. I don't want to participate. I don't really want to hang out if I don't trust you. Why would I put everything that I do into your hands as trustee over me? That's what's going on in the public. So you mitigate
Yeah,
by taking those things back into your own administration and your own managerial capacity to manage the affairs that have been entrusted to you. And again,
sounds excellent.
when you wake up and you see that, I get it. You didn't understand that this was going on, that this is what they've been doing. We've all had that moment. Really go, geez, this is not what they've been telling me in, all these years of schooling and all this other stuff. Every day on TV, every newspaper article, everything you hear on the radio, right? Supports the fiction of this system. But when you start to look at facts and you start to look at things, you go, I don't want to participate in that. And you step away. And then you're just managing your little box. That's it. Your family estate. You're redeeming your estate from the public. That's what this is all about. And subrogation is a tool for doing that.
Thank goodness.
All right.
And thank
Any other
you.
questions, guys?
Yeah, to finish mine,
Go ahead.
I really didn't volunteer. I think I was more voluntold. But
Yeah.
this presentation did make subrogation more understandable for me anyway, so I'm assuming it makes more sense for everybody else as well.
Yeah, I'm glad, Tom. Thank you. It is a tool. It is one of many tools for administration, and it is a way of securing rights, getting rights for paying off a debt that wasn't yours, and how to initiate and effect a claim. So I'm glad you were able to get something out of it. Are there any other questions, guys, before we wrap it up?
Hi, Dave.
Yes.
Yeah, Chris here from Ireland. Just wondering, does this apply to taxes, like income taxes?
Are you paying the taxes, or is the legal person owe the taxes?
Well, yeah, the legal person, the
It's
fictional.
the same.
Yeah.
It's the same. If someone owes a debt, the legal person has a duty to pay those taxes, and your efforts paid them. If you're setting up your trust estate the same way that we're talking about here, then your trust has a right of subrogation for paying all of those things. You personally would have a right as the surety that's been acting as surety, have those rights to subrogate for those taxes, yes.
Okay. Yep. Thank you.
You're welcome. Anyone else? All right, I'm going to stop the recording.